In a move that will make it much more difficult for landlords to properly screen tenants, the Wisconsin Supreme Court has decided to hide eviction records from landlords that are more than 2 years old. I'm Tony, and this is Real Estate Investing and Landlord News. All right, so I have an interesting article for you today, and it's going over the decision by the Wisconsin Supreme Court to basically remove eviction records from state records that are over 2 years old. Now, as I've mentioned many times before, our eviction history searches and our background checks, etc., they are absolutely necessary for landlords in order to put the best tenants possible into our properties, okay? We do not want to put tenants in our properties who do not pay the rent. It is pretty simple. And someone who has an eviction record on their history, right, that is just a few years old, well, they're going to be hidden. They're going to be hidden from landlords. We won't know. We're going to put these crappy tenants into our properties, and we're going to lose a lot of money because of that. And it's all due to this decision by bleeding heart liberals who believe they know better than the people who operate their own businesses, okay? It is absolutely idiotic. It is dumb as hell. And I can't stand this sort of decision because it doesn't look at the actual needs of the business owners when it comes to making a decision that is right for the business. Now, they always say, oh, well, there's people on there and they have an eviction filed against them, but there was no actual decision made against them. It's like, yeah, well, a lot of evictions end like that. A lot of evictions end before the case is finalized because the tenant says, okay, yeah, I owe you money. Yeah, I didn't pay the rent, but I'm going to leave before that. And then the landlord ends it. And why would a landlord do that? Why would a landlord go through an entire eviction process if the tenant has already left? They wouldn't waste their money paying a lawyer to do that. They wouldn't waste their time either. That would be dumb. So what we have is a lot of tenants who don't have a completed eviction on their history, but they're still garbage tenants. There's still people who do not pay their rent on time. There's still people who do not, follow the terms that they agreed upon in the lease. And other landlords should have the right to know about these sort of problems. Okay? As a landlord, I use this sort of information to screen through bad tenants. And in the case of people who've had multiple evictions filed against them or people who've had evictions filed against them, I am the ultimate decider of who I want to allow into my property. And people hiding facts from me, like that's not going to help me at all. It's not going to help anyone. It's not going to help the tenant. If the tenant doesn't pay their rent, do you think it's beneficial to the tenant to put them into a place where they're going to be able to accumulate more debt? How is that helpful for them? No, instead, you should allow the landlord to be able to screen the tenants, weed out those people who don't pay their bills or don't pay them on time or don't follow the terms of their leases, and then put the best tenant in their unit as possible. It frustrates me. It frustrates me. This is one thing that they try to restrict landlords from doing. Another thing they try to do is prevent us from looking at people's background histories, right? So we can't see their criminal records. Now, they're not talking about that in this particular case, right? But that is the next step. Okay, they want to say, okay, well, you can't see their criminal history. All they have is a few minor nonviolent convictions. Minor nonviolent convictions such as theft. If you steal from a store, if you go shoplifting from a store, I wouldn't be too surprised if that person wanted to steal from me as a landlord by not paying me my rent. Okay, or maybe if you did property damage, that's another one that it's a non-violent misdemeanor crime. Well, if you have a property damage conviction, would I be surprised if you just felt like tearing up my property? Of course not. Okay, that's why I say that it is absolutely necessary, even when you look at minor crimes. And then they're like, oh, well, these crimes happened a long time ago. Well, let me be the decider, not you, not the government. The government shouldn't be the decider on who gets to live in my property. Because when it comes down to it, I have hundreds of thousands of dollars invested in each and every property that I own. Hundreds of thousands of dollars. And you're telling me that I should have to accept a below average garbage tenant with evictions on their record with a bad criminal history and then just hope and pray that everything turns out right. Well, no, absolutely not. So before I get into the article, go ahead, hit the like, subscribe button, maybe leave a comment down below, and let me know what you think. So what do you think of this Wisconsin Supreme Court decision? Obviously, I don't live in Wisconsin. I don't invest in Wisconsin, but these sort of laws are being pushed all throughout the entire country. And this sort of thing could easily be happening close to where you are right now. And that's why I don't like to see it. I don't like to see it anywhere. Okay? This stuff, it spreads like the plague. Okay? You'll have activists, you'll have tenants' rights people. They'll be like, oh, well, this passed in Wisconsin, so let's try it here in Nebraska where I live, where I invest. So, that's why I don't like to see this sort of thing. And this is why I try to get the message out there that, hey, this sort of thing does not work. Okay? But anyway, let's get into the article and see what it says. This article is coming from the apnews.com, and it says Wisconsin Supreme Court sides with tenant advocates in limiting eviction records. All right, let's get into it. The Wisconsin Supreme Court voted Monday in its first public administrative conference in more than a decade to reduce from 20 years to 2 years the time when most eviction records must be kept on the state court website. The change was sought by tenant rights advocates who argued that the longer record keeping has made it more difficult for people with lower incomes to find housing. The court voted 4-3, with liberals in support and conservatives against, for shortening the record keeping on the state court website, commonly referred to by the acronym CCAP. Like, we have public records laws. I mean, as far as I know, most states or all states have these sort of public records laws, right? But if you notice that this in particular is it's limiting to a very specific civil case. Now, are all civil cases going to be limited to 2 years? I don't think so. Or all, are they going to destroy all records for the entire state after 2 years? No, just eviction records. So this Supreme Court is picking and choosing a very specific law for a very specific reason, and that is that they feel bad, like they said, oh, it's making it more difficult for lower income people to find housing due to having evictions on their record. Like, yeah, if you pay your bills on time, if you honor the contracts that you signed, then it wouldn't be more difficult for you to find housing. It is going to be more difficult for people who have horrible eviction histories, who have bad credit, who have criminal histories. It's going to be more difficult for them than the people who don't have these problems. And that is just a fact. Okay? That is why we can't we have to be able to put the best tenant in our property possible. Okay? How many times do I have to say this? We have to be able to put the best tenant in our property as possible, because we are risking huge losses. I just went through another eviction. I've been through so many evictions at this point. I've been in the game for over 10 years. So, as an investor, as a landlord for over 10 years, you're going to be going through evictions, especially if you have a lot of properties, right? I don't have a ton of properties, but I have enough. Okay. And so I've been through the eviction process. I just went through it again. Fortunately, I filed eviction against the tenant. The tenant decided to leave. But that, record of that tenant, me filing that eviction against that tenant is going to stick with that tenant. And hopefully the next landlord that tenant goes up to, right, that landlord does a proper tenant background check and sees that eviction that it was filed against them. Because that tenant didn't pay me and left, thousands of dollars worth of damage in my house. So I want to warn the future landlords, hey, this is a garbage tenant, okay? All of us have had garbage tenants, like the screening doesn't always catch them. But the next landlord should see this warning sign and say, hey, maybe I'm not going to rent to this person. Or maybe I'll require additional, security deposit, maybe a cosigner, etc., if I do want to rent to this person. But, that should be up to the individual landlord. Legal action of Wisconsin sought the change for cases where there is no money judgment against the tenant. At a hearing last month, tenant advocates said the change would help renters with eviction histories since many landlords rely solely on the statewide court website for determining whether to rent to someone. And that's a bunch of garbage, okay? Very few landlords, they rely solely on the court website for determining whether to rent to someone. That's a factor. Everything is a factor, okay? It's ridiculous to think that, oh yeah, if they see an eviction was filed, that's the only thing. No, no, it's not. Okay, yeah, I mean, if an eviction was filed, let's say 15 years ago, that might be still a consideration. But if you show that, hey, I have a solid rental history for the last 15 years where I didn't miss a single rent payment, I have my prior two landlords who I can use as references. I have a solid work history and income history. Yeah, I mean, then you've proven at that point that yeah, I am a trustworthy tenant, and that I might be willing to take a chance, worth the landlord taking a chance on. Okay, and but if you don't have that, and like if you have just a spotty rental history, your previous landlords don't want nothing to do with you, your credit is garbage, and you have this eviction filed 15 years ago, well, that's a lot of warning signs. There's a lot of different warning signs that landlords have to look out for. That's why I say thorough tenant screening, trust but verify. Trust but verify. Trust the tenant, but verify every single bit of information that is on their tenant application. Okay? So, interesting decision there by the Wisconsin Supreme Court. We'll see if landlords in Wisconsin are, better off or worse off after this decision. And we'll see if this sort of thing is spreading to other places throughout the country.